Let us continue reading about this case for reconveyance. An action for reconveyance is a recognized remedy, an action in personam. It is an action in personam, ha? So, dili siya action in rem. Lahi po ng personal action and real action. Lahi po ng action in personam versus action in rem. Available action for reconveyance is a recognized remedy, an action in personam, available to a person whose property has been wrongfully registered under the torrent system in another's name. So kung imong problema, napatituluhan ang imong yuta, pero ang nakapangan dito sa titulo, dili ikaw, si Pedro, ang na-registered owner sa imong yuta, then it would be wise to consult your own lawyer about a possible action about the possible filing of an action for reconveyance. Of course, imong abogado na mag-evaluate ana whether mo fit ba siya sa requisites or not, no? In an action for reconveyance, the decree is not sought to be set aside. Wala gipawalang bisa ang titulo. It does not seek to set aside the decree. So katong desisyon nga nahimong titulado tong yuta, dili to mao'y gi pawalang bisa. Gibalhin lang gikan sa sayop nga ngalan padong dito sa sakto nga ngalan sa tag-iya, no? Sa pangalan sa sakto nga tag-iya. Name of the rightful owner. Sakto ba akong pag-translate, ha? In an action for reconveyance, the decree is not sought to be set aside. It does not seek to set aside the decree, but respecting it as incontrovertible and no longer open to review, it seeks to transfer or reconvey the land from the registered owner to the rightful owner. So, muna siyang sitwasyon kung the registered owner is not the rightful owner. A reconveyance is always available as long as the property has not passed to an innocent third person for value. So for so long as the registered owner is the registered owner is privy, no, or is not a third party, is not a stranger, is not a buyer in good faith, reconveyance is always available. There is no quibble that a certificate of title, like in the case at bench, can only be questioned through a direct proceeding. The Municipal Circuit Trial Court and the Court of Appeals, however, failed to take into account that in a complaint for reconveyance, the decree of registration is respected as incontrovertible and is not being questioned. What is being sought is the transfer of the property wrongfully or erroneously registered in another's name to its rightful owner or to the one with a better right. If the registration of the land is fraudulent, the person in whose name the land is registered holds it as a mere trustee, and the real owner is entitled to file an action for reconveyance of the property. Ownership is different from a certificate of title. The fact that petitioner was able to secure a title in her name did not operate to vest ownership upon her of the subject land. Registration of a piece of land under the torrent system does not create or vest title because it is not a mode of acquiring ownership. A certificate of title is merely an evidence of ownership or title over the particular property described therein. It cannot be used to protect a usurper from the true owner, no? So it cannot be used to protect the wrongful registered owner, no? Kanang napanganra sa imong yuta pero di gud ikaw tag-iya, dili na siya makaprotect nimo imong titulo. Hassle lang para sa rightful owner, hassle para sa tibok sa tinuod nga tag-iya, because siya may mo file sa kaso. Usahay medyo subidahon pa gyud kay syempre titulo imo mangalan, siya may plaintiff, so siya may burden of proof, no, para mo ma-prove yung cause of action. So, hassle. Although na kay remedy, pero di po lalim, mo gasto og kaso, no? A certificate of title is merely an evidence of ownership or title over the particular property described therein. It cannot be used to protect a usurper from the true owner, nor can it be used as a shield for the commission of fraud. Neither does it permit one to enrich himself at the expense of others. Its issuance in favor of a particular person does not foreclose the possibility that the real property may be co-owned with persons not named in the certificate, or that it may be held in trust for another, or that it may be held in trust for another person by the registered owner, as correctly held by the Court of Appeals. Notwithstanding the indefeasibility of the torrent's title, the registered owner may still be compelled to convey the registered property to its true owners. The rationale for the rule is that reconveyance does not set aside or re-subject to review the findings of fact of the Bureau of Lands. In an action for reconveyance, the decree of registration is respected as incontrovertible. What is sought instead is the transfer of the property or its title, which has been wrongfully or erroneously registered in another person's name, to its rightful or legal owner, or to the one with a better right. The rationale for allowing reconveyance, despite the finality of the registration, is that the issuance of a certificate of title does not create or vest ownership to a person over the property. Registration under the torrent system is not a mode of acquiring ownership. A certificate of title or a certificate is only a proof of ownership. Thus, its issuance does not foreclose the possibility of having a different owner, and it cannot be used against the true owner as a shield for fraud. In an action for reconveyance, the parties are obliged to prove their ownership over the property. Necessarily, the parties may present evidence to support their claims. The court must weigh these pieces of evidence and decide who between the parties is the true owner. Therefore, it cannot be bound simply by the factual findings of the Land Registration Court alone. An exception to this rule is if the party claiming ownership has already had the opportunity to prove his or her claim in the land registration case. In such a case, res judicata will then apply. When an issue of ownership has been raised in the land registration proceedings, where the adverse party was given full opportunity to present his or her claim, the findings in the land registration case will constitute a bar from any other claim of the adverse party on the property. However, this is not the circumstance in the case at bar. The spouses po were not able to prove their claim in the registration proceedings. Thus, res judicata cannot apply to their action for reconveyance. So, ang sunod na nga topic ani na ay theory from the spouses aboitis that the deed of absolute sale between Seriaco and the spouses po is fake and fraudulent. They argue that this is evidenced by certifications of the document's non-existence in the notarial books, and that spouses po's failure to enforce their rights over the property until 18 years later. They also claim that the deed of absolute sale is inadmissible as no documentary stamp was paid and affixed. So, muna isunod nga theory nila sa spouses aboitis. Pero kana marag sa sunod na nga video, no? Kay taas-taas pa jud. Tunga pa ta. But di ba? Sulit sa time. Daghan og lessons kini nga decision. Nindot jud siya pagkasuwat. Grabe pod niya ang iyang explanation ba. So I'll see you in the next video.